Right, everyone, happy Tuesday. Welcome to the 187th District Court. I'm sorry, who said hi? Thank you, Alex Sharp. You're so awesome. All right, I'm gonna call the docket to the people who have clients who are in custody. Their name will not be called. To everyone else, when you hear your name, please stand so that I will know that you are here. If I don't know that you're here, then you're not here and a warrant may be issued for your arrest. To those of you who are waiting for your attorney is probably zooming in another courtroom or either is in person in another courtroom, is in out of county. They will be here as soon as they possibly can. Our jury trial will begin at 1:30. Carlos Guerra. Luis Orozco. Thank you. Roberto Espinoza.
President Judge, we have a plea report over the paperwork.
All right, thank you. John Martin Espinoza. John Martin Espinoza. All right, thank you. Damone Wyatt.
Yes, ma'am.
Thank you. Mary Vidal. Mary Vidal. Andrew, thank you for being here. Jose Parada.
President Counsel.
Thank you. Mario Contreras.
He's present.
Thank you. Zachariah Milton. Thank you. Renee Espinoza.
Here.
Stephen Velasquez.
Here, ma'am. President Counsel.
Thank you. Calvin Johnson.
Present with counsel.
Thank you. Jimmy Aguirre.
Judge, you President, we have deferred.
All right. Jeffrey Kesey. Jeffrey Kesey. Carlos Gonzalez. Carlos Gonzalez. Rodolfo Del Bosque. George Moore. Carlos Guerra. Michael Jimenez. Jose Lozano is at 1:30. McAfee 1:30. Is the attorney here on Robert Andrade? Felipe Garcia. Thank you. Roberto Martinez. Carlos Garcia Jr. Carlos Garcia. Okay, thank you. All right, is there anyone whose name has not been called? Yes. April Rodriguez. Anyone else?
Marina Ray got her NPR this morning.
Oh, yes, I'm not calling the persons in custody. All right, thank you. All right, so these are the rules of the court. If you want the court and you're ready for the court to hear your case, you need to approach the clerk. The clerk will place the file. The cases will be called in order in which they are received by the court. As you can see, there's a post there. So please do not pass that post to approach the bench unless it's something that needs to be discussed off the record, or if it's something that's, of course, legally ex parte and ethically ex parte. All right, everyone, please confer.
I don't have a file.
Judge, you know, they're not doing pre-indictment setting, right?
No, we do not.
Okay. So if my client's mom shows up and asks about a pre-indictment setting, I just send her deputies.
I'm sorry.
I have
Okay,
a client's mom who's gonna show up and didn't believe me when I told her it's not a real setting.
yes. Okay, well, if they show, we'll see what we can work out. That's,
Is this the marker I don't pass, Judge?
yes. Your ticket is your file.
It's up there.
Okay, just give me a moment.
Okay.
All right, and if you have a seat, I'll call you.
Oh, okay.
Yes, yes.
Okay, okay.
So once the file, once you told the clerk, and they place the file, trust me, I'll call you.
Okay, I'm gonna go step away and get another file.
Okay, thank you.
Pull the sticks out and pull the whatever.
Yeah.
Marina, right? Up to the back. Okay, I'll go.
Yeah.
before
we have it.
Your Honor,
Yes,
good morning.
morning.
I sent you a chat.
All right, just give me a moment.
Thank you.
You're welcome. Okay. Okay.
I'll make some notes here. Yeah, so you can start that. Yeah. Yeah. So we should get just if you tell the clerk. You're ready to. Yeah. Just talk to you. Yes. No.
I don't know, Marcus. He was dealing with you on it, but Marcus is out this week, so.
Yeah, I mean, it was the misdemeanors that closed out, just enhance the situation.
Look back. This hasn't been stamped.
We gotta see.
Sworn to subscribe today.
Oh, okay,
I need to follow. All right. look back.
Oh, you think? Okay.
Yes.
Okay. Philip Garcia.
Yes, Philippe Garcia.
Philip Garcia.
Philippe Garcia.
Philip Garcia.
His name is Philippe. It's not Philippe.
Yeah.
Yeah, that's why I was
Sorry.
sorry. Yeah. All right, Philippe Garcia, if you come forward, please.
Mario Lucio Contreras.
One more.
Hi, Ms. Garcia. Good morning. My understanding, could everyone please whisper? All right, Mr. Garcia, you were brought in for compliance hearing, but my understanding, I just received an email from probation that you turned everything in that you need to turn in, okay?
Yes, ma'am.
So you're doing great work. So do you have any questions about anything?
No, just I didn't receive a reminder for.
Yes, they told me, yes, so that's fine. So how's your license coming along?
Good, I got the instructor from work, he wrote me a letter saying that I am able to obtain it once, I get off probation and stuff.
Well, if you keep doing well, then what we'll do is we can see about an early termination. Ms. Abrams,
Yes, Your Honor.
with Mr. Garcia, can you look into seeing that he has everything done so we can maybe do an early termination? But you're gonna have to put in the work, okay? All right, do you need to speak with him anymore, Ms. Abrams?
You can just check with me on the way out.
All right, so probation is in the back to the left before you go completely outside the courtroom.
Yes, ma'am.
All right, keep up the good work.
Thank you, ma'am.
All right, you're welcome. All right, could I see the parties on Jacob Brown? State if you're ready.
Yes.
All right. All right, so, Mr. Smith, have you had a chance to speak with Mr. Brown? Does he want the reconsideration?
He does, Your Honor.
Okay. Brenda, can we go on the record? All right, the court is calling. And can I get this file?
I ordered it just, I don't have it.
Okay. All right. So the court is calling 2020 CR 0430, State of Texas versus Jacob Brown. Do I have parties announced for the record for the state?
Brittany Sparks.
For the defense.
I'll do it, Smith.
Right. And do you represent Mr. Jacob Brown?
I do, Your Honor.
So you filed the motion to reconsider. It's the court's understanding that there was an agreement that was reached on the motion to revoke,
That is correct, Your Honor.
Yes.
but different things were decided. I'll say that different things were decided. And you're asking the court to reconsider, is that correct?
It is, Your Honor.
All right, so your client is not here. The court did order to have him bench warranted, but he was moved to a new location. So we're still working on having him bench warranted back to Bexar County. Do you have any objections to us proceeding without his presence?
No, Your Honor.
All right, and have you had a chance to speak with Mr. Brown?
I have, Your Honor.
And when's the last time you spoke with him?
2 days ago, I believe. No, that's not correct. Friday, you said 4 days ago.
All right, and does Mr. Brown still wish the court to reconsider?
Yes, Your Honor.
Okay. All right, and I know that there's time limits.
Yes, unfortunately.
All right. So what are you, I will grant your motion to reconsider unless there's an objection from the state.
No, Judge, there's no objection.
All right, and what are you requesting?
We had an agreement, I believe it was for Saturday.
Yes, Judge. It was for Saturday.
All right, what I'm going to do then is I'm gonna order him back to San Antonio. Let me see, do I have something to show if he was on deferred adjudication? I need something. Do you know if your client was on deferred adjudication or regular?
He was on deferred. Your Honor.
Thank you. What the court will do then, the court will follow your agreement, reinstate his deferred adjudication. And I'm gonna require that he remain in custody and he be considered for felony drug court. And if he's not accepted in felony drug court, then we'll consider another inpatient treatment facility.
Very well.
All right, are both parties in agreement with the deferred adjudication being reinstated? State?
Yes, Judge.
Yes, Your
Defense?
Honor.
And are both parties in agreement with the conditions being altered and amended to include felony drug court? State?
Yes, Judge.
We
Defense?
are, Your Honor.
And are both parties in agreement with Mr. Brown remaining in custody until he is placed in felony drug court stage.
Yes, Judge.
Yes, Your Honor. That says two.
And if Mr. Brown is not accepted by felony drug court, are both parties in agreement with him then remaining in custody until accepted into an inpatient
Yeah.
facility, be it SATA, safety, or whatever the facility that is available may be safe?
Yes, Judge.
We
Defense.
are, Your Honor.
All right, then, is there anything else for the record?
No, Your Honor, we appreciate you clearing this up.
All right, Mr. Smith, we're off the record. Mr. Smith, what I'm gonna need you to do is make sure that you stay in touch with the court coordinator so we can know when Mr. Brown will actually be brought back. Ms. Ferguson, do you have any idea when Mr. Brown will be here?
Maybe about 20. Because he was shipped out to another.
All right,
So we have to review the whole bit. for him.
all right, so we're looking at 20 days. Just be sure to check in. Ms. Ferguson, can we set this for the 15-day mark? And what date will we come back?
I can do the 23rd.
All right, so we're gonna come back on June 23rd to make sure that's done. And then Mr. Smith will need a new order of probation. Ms. Abrams,
Yes, Your Honor.
so on Jacob Brown, the cause number is 2020 CR 0430. His deferred adjudication is being reinstated. He's being bench warranted back. We're gonna recall this for June 23rd, just to make sure that the process has happened. What I'm gonna wanna do is alter and amend his conditions to include felony drug court, and he's to remain in custody till accepted to felony drug court. And if you get in touch with felony drug court to let them know that, please put him on their list.
Yes, Your Honor. And verify this CR number for me one more time. Is 0430?
0430,
Yes, ma'am.
and it's Jacob, JACOB Brown.
Yes, Your Honor.
All right, and I'm gonna give you this, Mr. Smith, to take back. Just let me fill this in. All right, here you are, Mr. Smith. You're welcome.
Appreciate it.
All right, who is here on Jimmy Gary?
I am.
Just give me a moment. Let me find him on the small docket. All right, what is happening with Mr. Gary?
Judge, I conferred with Mr. Ryan Brumer. He's made an opposed offer. However, I pointed in the direction of bad video. Previous prosecutor I had told about the video has left the office. So Mr. Brumer had would like the opportunity to watch the video.
All right, so there's a Coban. Has
Yes,
he given you a time frame on that?
no, Judge, but he did promise to reach out to me after he watched it. Joe Ray was the last prosecutor, but I asked to watch the video. But yes, that's it.
So does the state have the video in their possession?
Well, I have it, so I'm assuming they do.
All right,
It's in the
so,
e-discovery.
so you're just asking that the state get a chance to watch that, and then,
That will, I should be dispositive.
all right, Ms. Ferguson, on Jimmy Gary, can I have a 3-week reset?
You said a 3 week.
Yes.
I can do the 23rd.
All right, it'll be June 23rd. And you say it's to view Coban?
It's the in-car camera at Coban. What day of the week is it?
Okay, I just give the dates.
It's a Thursday.
That means my birthday's on Wednesday
Oh, happy birthday month. In June.
in June. Yeah. Guess I have a deadline to sign up for Medicare.
All right, Ms. Ferguson will give you a reset date for June 23rd.
Thank you.
You're welcome.
Then I need to stick around for another one.
All right, thank you. All right, Ms. Ferguson, if you can give them a reset date on Jimmy Aguirre for June 23rd. Okay, all right, thank you. And you have the court's order, right, on Brown?
Yes.
All right, thank you.
Drop it off in the back.
All right, who are the parties on Carlos Guerra? Carlos Guerra. Just waiting for your attorney. All right, if you want to see if you can grab him, we'll take up your matter. Who's the attorney on Jose Parada? Yes. All right, before Mr. Parada comes up, what is happening here today?
Judge, we were announcing ready for trial. I'm not sure what the.
Okay, all right, then, yes.
Once I have a question here, yeah.
Okay, thank you. Who's here on Roberto Martinez?
That's fine.
Yes. Mr. Roberto Martinez is not present?
He is not. I attempted to get in contact with him through the number that I had from the appointment and the number that PR Bonds had. Neither number is functional.
All right, Deputy Lord, can someone see if Mr. Roberto Rangel Martinez is in the hallway somewhere? Is there a prosecutor available? All right, thank you. Court is calling 2022 CR 2975, State of Texas versus Roberto Rangel Martinez. Do I have parties announced for the record for the state?
Grace Marks.
For the defense?
James Hunt.
All right, and Mr. Hunt, your client is not present. Docket was at 9 a.m. It is now 10:05 a.m. This case was actually set on April 25th. At that time, the defendant was a no-show at 12:39 p.m. And on that date, the docket was at 9 a.m. The court then recalled the case for May 23rd, and the defendant was not present at that time. And the court then gave defense counsel a chance to locate their client. So we're back on May 24th. Have you had any contact with your client? All right, Deputy Laura or Deputy Mejia, did you call for Mr. Roberto Martinez?
Yes, I did.
And was he present or any answer?
No, man.
And for the record, he is not in the courtroom and he is not on the Zoom screen. State,
Yes, Judge, we'd ask that you forfeit his bond and issue a warrant.
defense.
I don't have a valid objection. Your Honor.
All right, then bond forfeiture will be issued and he will be remanded without bond. If you're able to make contact with your client, then the court will reconsider.
Thank you.
All right, you're excused. Thank you. All right, are the parties ready again on Carlos Guerra?
Yes, Your Honor.
All right, Mr. Guerra, you can come forward. Court is calling 2021 CR 1469, State of Texas versus Carlos Guerra. Could I have parties announced for the record for the state,
Ryan Groomer for the state of Texas.
for the defense?
Thomas, sir.
Are you Mr. Guerra?
Yes, ma'am.
Mr. Guerra, I'm going to show you what's entitled motion to revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Carlos T. Guerra Jr. who was placed on community supervision in 2021 CR 1469 for the offense of driving while intoxicated second on March 30th, 2021 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Judge, violated condition number 17 in Bexar County, Texas. The defendant Carlos T. Guerra Jr. did then and there fail to comply with the rules, regulations, or instructions of the in-home breathalyzer device, and that the defendant failed to submit 161 required breath tests on the device from March 30th, 2021 through March 30th, 2022 in violation of condition number 17.
How do you plead to that? True or not true? I didn't hear you.
True.
Yes.
We'd waive the remaining conditions, Judge.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 17, the court could find it true, grant the motion, sentence you to 1 year in the Bexar County Jail and up to $1,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 17?
Yes, ma'am.
Court is finding violation of condition 17 true. Is there an agreement?
There is, Judge. We'd ask the court to deny the MTR and alter and amend. This part, Judge, we may have to kind of we'd ask the court for guidance on how to do this. Essentially, Mr. Guerra is on a probation out of Gonzales County that they've ordered him to go to safety. What we'd like to do is just run everything concurrent on this probation, but alter and amend to allow him to go into safety as part of his other probation in Gonzales County case number 193-16-A.
All right, what is the case out of Gonzales County?
It's a drug case, Your Honor. Possession.
So when is he scheduled to go to?
In 2 weeks, Your Honor. And in the meantime, he bonded out over here on the MTR, and pre-trial is telling him he needs to get a driver's license. Okay. Until he goes, we need to fix a pre-trial violation.
How much time has he served in jail? Does anyone
Not
know?
much, Judge. I believe he has maybe a day when it first, I think he bonded out both times.
3 days. All right, so for me, he's on this court on a misdemeanor case.
I understand, Judge. I think our thoughts were maybe we were going to ask you to potentially term, but I don't think we can. I think he has to go ahead, correct?
No.
Yeah.
So he'd have to do time.
Correct.
And to me, it seems the appropriate thing to do so he can get to his inpatient treatment and Gonzales to safety would just be to revoke him.
I mean, I think that may be one way to get there, Judge. I think the main thing we want to do is not conflict anything that would keep him out of going into inpatient if that's what he's going to do. So I think that's a way to do it too.
Judge, satisfaction. Absolutely.
Yes.
Yes.
Well,
Agreed.
no, I'm not saying
Okay.
time served. I'm not gonna allow him to walk out of this courtroom and he hasn't done what he's supposed to do.
Oh, yes, Your Honor, I've been doing it since I got out. I haven't missed anything at all. I
Pro-
comply with everything, man.
Probation? Has he been in compliance?
I did drug tests last weekend. I just recently did my whole month of calibration as well, man.
Your Honor, we don't have the calibration for the last month. The month before, it looks like he missed 12 blows into the device. His drug test last recorded was negative, and that was March 16th. Now, if he's submitted drug tests since then, he was sent to the last lab last week. However, that has not come back yet. There was a drug test March 27th, and it was positive for alcohol. Or that was on the alcohol monitoring
Yes,
system.
because, I had mouthwash memory, and I talked to the person that said that I was high. I should have gone again, but I didn't. That's because I missed in the morning, but I haven't missed anything
All
at
right,
all.
so here's my question. Who's his attorney, defense attorney in the other county?
I was.
All right, so do you want to contact the prosecutor there and see if he's taken into custody here to serve his sentence on this case? You know, their course can have him transferred there.
Okay, well, over there, he already has a date certain to turn himself in to go to treatment.
Okay, which date is that?
June 9th, I believe, man. They gave me time to get work in order, papers, and move my apartment, stuff like that for my kids. And I'm still blowing my machine as well, the home breathalyzer as well, man.
All right, this is what I'm gonna do. I've taken his plea of truth. So what we're gonna do is see if he turns himself in on June 9th. Who has a phone? Let's not do that thing where we have a phone and then we look around at somebody else and pretend it's somebody else's phone, like, what?
I don't know who's back sister.
Well, I mean, I don't know what kind of offense that would be right now, so I don't think it's a felony. All right, so I do know that sometimes safety won't accept when you have an open case. So if you can coordinate with the people in the other county, what I'll do is, he's already entered his plea of truth. If you can already get an affidavit for him, I can sentence him on this case without him being present once he's transferred to Saturday.
What kind of affidavit do I need? Affidavit.
From him saying that he is okay with you, with him being sentenced and taking a sentence on this case without his presence.
Okay. So we just wait for guys for him to go into custody there?
Yes. So my understanding, he's going on June 6th. Is that correct?
Yes.
June 9th, ma'am.
What?
June 9th.
June 9th?
Yes, ma'am.
All right, so he's going on June 9th. So we're going to set this case here for June 9th. But you need to talk to the prosecutor there and let them know that since he's turning himself in on June 9th, don't worry about this case being open because we'll take care of it once I know that he is being transferred to safety.
So after he turns himself in, I come and you sentence him.
Yes,
With an affidavit, I agree to be sentenced in abstention.
yes.
I understood.
All right, so Ms. Ferguson, on Collins, Guerra, we're gonna reset it for June 9th, but the defendant should be in custody by that time in the other county.
And what sentence will the court contemplate?
I'll contemplate a sentence that will make sure that he goes to safety.
Thank you.
Sure. So I just want to make sure that he's sent to safety.
And
And
he
it
will
would
get
help,
credit, if he does well, he gets credit for the time.
and if it would really help the court if we have some documentation for the court's file that he's going to safety.
Yes, I will go ahead and do it as normal right now.
All right, and Ms. Ferguson, so we're coming back on June 9th on Mr. Guerra. And the court, Mr. Guerra has accepted your plea of truth, and the court is finding it to be true, and your sentence will take place on June 9th.
Thank you.
You're welcome.
Thank you. Maybe you see, sir?
Reset form.
you on here. Said who-
Oh, I'm sorry. Let me have it filed back. I need to add something extra. And Mr. Hillary, what county was that?
Gonzalez County.
All right, thank you.
Thank you.
All right, here you are.
Oh, Your Honor,
Yes.
can you turn the private light in like the day before? Or you already sent it in?
I don't want any type of downtime.
Okay,
So I'm sure they will take his breathalyzer from him when he turns himself in, and Bear County will have to get the breathalyzer back the best way they can. All right, Mario Contreras. Yes, Mr. Contreras, come forward. All right, good morning. So what is happening with Mr. Contreras?
He's here, Your Honor. We need a setting to review some discovery work that just became available.
Just so what happened on this case is it's one of those, he had a misdemeanor, picked up a new misdemeanor family violence case. The old case was closed out and hence is to continuous. That old case was never uploaded. That discovery was uploaded into this case. And so I had DA and IT do that today. So it should be available to Mr. Baba tonight.
Okay, I'm just wondering, this is the 2021 case, and this is the first setting on the docket, which I'm finding odd.
That is odd. I didn't know.
Yeah, it is on.
Ms. Ferguson, when you get a chance, can you check to see why a case with indictment number 2021? This is like the first setting. All right, thank you. It's 2021 CR 9079. It's Mario Contreras. So that's something with the system, not with the court. But we're going to try to find out where the breakdown in the system is so that we can make sure that this doesn't happen again. All right, so it's the old case that needs to be uploaded.
Yes, sir.
And Ms. Ferguson, if I can get a 30-day reset on Mr. Contreras, please. And it's for discovery.
I can do June 30th.
All right. We're gonna come back on June 30th. And at 9 a.m.
Yes,
Just get a reset form from Ms. Ferguson.
Thank you, Judge.
You're welcome. Okay. That's okay. Frank Garcia.
Good morning, Judge.
Good morning.
That case is set on Thursday. He's an inmate. I was here with Jimmy Aguirre, who's also conferring with Ryan on Mr. Garcia. Informed me that Mr. Garcia has another indicted burglary of a hab. And he has Sharon Thorne as the court-appointed attorney. I was appointed on this case. Ryan said that he'd like to restart negotiations. We both decided that it would be preferable to have only one attorney, no longer on the court-appointed wheel. That's why Sharon was appointed subsequently, and we were asked that I be removed and appoint Sharon, who knows to be here Thursday on the unrelated burglary.
All right, so let me do this. Let me keep you on this case till Thursday, because I don't want anything where maybe Sharon is not up to speed on this case.
They just asked, this is just our approach today.
Okay, all right, so if you can come back on Thursday and we'll see if she's up to speed on everything. If she is, then of course, you can be removed. Okay, all right, thank you. Who's the parties on Megan Moran? Yes, and have you conferred with the state?
I did a confirm, Mr. Governor, on that.
Okay. And see, I received notice of this, and I sent an email, and I said, contact the attorney. And they're like, oh, we can't find Mr. Hoyer. So I'm like, I know you will find him. I'm like, he's
Look for the
always on
extension.
time. Yes. All right, so the other email that I got, that they wanted her to reside at this home, but they also wanted her to be allowed to work.
Correct, for it to be a tracking instead of full.
Okay. So you're asking for tracking?
Yes, sir. That should allow her to work, right?
Yes. All right, for this one, if you'll just have the clerks stamp it.
Yes, Judge. Thank you.
You're welcome. Have a good one.
You too.
All right, Libby, can I have that file so I can write that in? All right, Mario Contreras. I'll put that in the file just so, or no, if you could write that in the file that he was picked up. Thanks. All right, who is here for Calvin Johnson?
I'm here.
All right, and Mr. Johnson can come forward. All right, so what is happening with this case?
We did get a plea offer on that. He's still considering that, but otherwise,
So was the offer tendered today?
no, it was the first time we report. They reaffirmed it today.
Because I saw it was tendered on April 25th. Ms. Ferguson, on Calvin Johnson, can I have a 2-week reset for plea deadline, please? And are you representing him on both of his causes?
Yes.
All right, because on cause number 2022 CR 2946, they still have Mr. Simmons as his attorney.
He was the bonding attorney, but I'll go ahead and make sure that that's correct.
All right, so your plea deadline date is gonna be June 14th, so we'll come back, and at that time, you need to let the court know whether or not you're accepting the offer or not, Mr. Johnson. Defense, have you received all the discovery?
On one of the cases, so I gotta clear up that other issue so I can get the rest of the discovery. But,
Well, just
one
one
of them.
moment. Then your plea deadline date is not gonna be June 14th. Ms. Ferguson, the June 14th date will be for discovery for them. Yes, because she's not listed as the attorney on 2022 CR 2949, so she hasn't received the discovery on it.
Okay.
So that will be another discovery, and then after that, it's gonna be a quick turnaround for a plea deadline date, okay? All right, so we'll come back on June 14th. Is that correct, Ms. Ferguson?
Yes.
All right, if you'll just get the reset form from Ms. Ferguson, and please go to the back and clear that up with the clerks.
Okay.
Thank you, Judge.
You're welcome.
Judge, I'll be right back.
All right. Oh, let me get your files, clients and husbands.
One.
So you'll pull the files out. All right, deputies, do you have John Espinoza out?
He's in custody.
Okay. All right, and where is Renee Espinoza?
He's here, Your Honor.
Renee Espinoza? All right, thank you. All right, Mr. Renee Espinoza, you received the offer, Ms. Swimmer,
Yes, ma'am.
and is your client rejecting that offer?
Yes, ma'am, he is.
All right, Ms. Ferguson, on Renee Espinoza, I need a jury trial date, please. All right, and this will be your jury trial date and a plea deadline date.
Yes, ma'am.
And I'm trying to move as quickly, as quickly as possible so you can get to where you
No
need to
problem.
go.
I'm in no hurry, Judge. Take your
Okay,
time.
awesome.
I can do. I can just do July 26th on that one. I know I'm gonna be at a family reunion in Wisconsin.
Okay, is it already too many people at the family reunion?
It's the only time we see our family, Judge. And my mother-in-law is 96.
Oh my gosh, you gotta be there.
Yeah, she's amazing.
So where is it going to take place?
In Racine, Wisconsin, which is where I'm from.
Oh, wow.
Both my husband and I are from, we grew up next door. I know it's,
Oh, well, you always knew each other, so there are no secrets from childhood.
well, actually there are, but
August 9th.
that'd be fine, Judge.
All right, your jury trial date is going to be August 9th, Mr. Espinoza, and that will be your last opportunity to enter a plea as well. If you enter a plea on that day, of course, there will not be a jury trial, but if you do not, then you will be going to jury trial on that date. Do you understand? All right, Ms. Ferguson is going to give you a reset form.
I know you called it earlier, but I wanted to look at that court file if you had it. Thanks, Jim.
And then, Ms. Warmer, they're bringing up Mr. John Martin Espinoza for you.
Thank you.
All right, everyone, just give me a moment. All right, are the parties here on Stephen Velasquez? All right, the court is calling 2022 CR 2469, State of Texas versus Stephen Anthony Velasquez. Can I have parties announced for the record for the state,
Ryan Rumor for the state of Texas.
for the defense?
Barry Hitchings, attorney for the defendant Stephen Anthony Velasquez with a V.
All right.
Junior.
And are you Mr. Velasquez?
Yes, Your Honor.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor, and I've gone through it with my client.
Court will find that the state is in compliance with discovery. Mr. Velasquez, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Velasquez, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand your charge of felon in possession of a weapon? The range of punishment for that offense is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement, it gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your
Do you
Honor.
believe he's currently competent, was legally sane at the time of the offense?
I believe he is, Your Honor, and he was at the time of the offense. He was.
Mr. Velasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a US citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 3 years in the prison. There's a $500 fine. State doesn't oppose the defendant being allowed 30 days to return for sentencing. But as a part of the plea bargain agreement, defendant agrees he is subject to the full range of punishment if he does not appear for sentencing. Do you understand? If you do not appear for sentencing, then your plea will stand, whatever the court's findings will stand. And if you don't show up, your range of punishment will then be anywhere from 2 to 10 years in the prison. Do you understand?
Yes, Your Honor.
Defense, is that the agreement?
It is, Your Honor. His 61-year-old father, Stephen Anthony Velasquez
Oh,
Sr.
we'll get to that point, just a second. Did you understand that to be the agreement?
It is, Your Honor.
State, is that the agreement?
Yes, Judge.
Mr. Velasquez, did you understand that to be the full agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not been, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's plea?
Yes, Judge. State what offer states exhibit number 1.
No objections, Your Honor.
Mr. Velasquez, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses, statements, and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments or review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Mr. Hitchens, so what is the issue with him not being sentenced today?
Well, his 61-year-old father, Stephen Anthony Velasquez Sr., his namesake, has throat cancer. And his father is the U.S. Navy Chief Bozeman, retired veteran. And this allows Mr. Velasquez Jr. to take care of family situations within the next 60 days before his sentencing commences.
All right, you all are asking for 30 days.
I'm sorry, 30 days. 30 days.
All right, so are we going to come back in 30 days and ask for more time?
No, it's 30 days is more than sufficient.
All right. Ms. Ferguson, can I have a 30-day reset for sentencing on Mr. Velasquez? Yes. All right, we'll be back on June 28th at 9 a.m., Mr. Velasquez.
Thank you, Your Honor.
You're welcome. They're going to give you a reset form. Okay. All right, John Martin Espinoza. All right, I believe this is family violence on John Martin Espinoza.
Yes, yes.
All right, so Ms. Wimmer actually has a panel. I guess, are you waiting for a verdict or?
No, we're waiting to pick the 12 lucky people.
All right, so, and which court is this?
227.
All right, so Ms. Ferguson, on John Espinoza, I need an early trial date for this.
Judge, I had conferred with Ms. Ferguson about resetting this Mr. Espinoza on the same day as Renee Espinoza, but Mr. Espinoza would like a sooner date than August 9th.
Yes, the court does as well. So Ms. Ferguson, I need an early date for jury trial for Mr. Espinoza. And Mr. Espinoza, Your attorney is actually selecting a jury in another court. And as much as we try, you know, we can't be in two places at the same time.
That's right.
I think that's what Bobby Womack said.
I'm sorry, that reference doesn't.
Oh my gosh, we
What
don't
ring
have,
would
I don't
be,
have musical people. Charles Bronk knows if he were here.
He is here.
Yes, I told him, as Bobby Womack would say, you can't be in two places at the same time. He knows my reference. All right, so June 14th.
Perfect.
All right, Mr. Espinoza, because your attorney is in jury trial in another court, June 14th will be your jury trial date, and it also will be the last time for him to enter a plea if he wants to enter a plea.
Yes, ma'am.
All right, Ms. Ferguson will give you a reset. All right, who are the parties on Billy Denise Taylor? Billy Denise Taylor. All right, as soon as your attorney is here, we'll take that matter up. Robert Andrade. Yes. All right, on this case, Mr. Martinez, you may want to confer with the state. It was about the Universal City issue, so you can confer with them so that we can get the right, Mr. Martinez, I'm sorry, Mr. Andrade, my understanding is that there is an issue with your locations and where you will be. So your attorney is just going to confer with the state so we can craft a different order, okay? Luis Orozco. Luis Orozco. And this is criminal trial division. All right, the court is calling 2018, those are not done yet. Court is calling 2018 CR 10083W, State of Texas versus Luis Orozco. I have parties announced for the record for the state.
Brittany Sparks.
Efrain Torres Jr. for Mr. Luis Orozco.
And are you Mr. Orozco?
Yes, ma'am.
Mr. Orozco, I'm showing you what's entitled motion to enter adjudication of guilt and revoke probation. Did you review that document with your attorney? Did you understand it?
Yes.
Are you the same Luis Orozco who was placed on deferred adjudication in 2018 CR 10083W for the offense of possession of a controlled substance, penalty group 1 less than 1 gram on September 26, 2018 for a period of 3 years? Is that you?
Yes.
And extended for a total of 1 year? Is that you?
Yes, sir.
All right, state.
Yes, Judge, violated condition number 5. In Bexar County, Texas, the defendant, Luis Orozco, did then and there fail to report to the supervision officer as directed for the months of November and December 2021 in violation of condition number 5.
How do you plead to that? True or not true?
That's true.
We make all other violations.
Any objection?
No objection, Your Honor.
All right, Mr. Orozco, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Did you understand? Need you to speak up?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? Court is finding violation of condition number 5 true. Is there an agreement?
Yes, Judge, we're asking that you deny the MTR and refer the defendant to drug court with UA hotline until he's accepted.
That's correct, Judge.
All right, Mr. Orozco, are you asking the court to follow that agreement?
Yes.
All right, if you're drug tested today, what are the results going to be?
It's just for marijuana.
And what else?
That'll be all.
So why are you not reporting to probation? Do you want to go to the state jail facility?
No, I don't. I had dropped the ball. It was on me. I messed up, but I'm working on it now. I'm actually trying to like stay on it.
You see everybody in that box over there?
Yeah.
They say they're working on it. So if you want to continue down this path, we can get you an orange uniform. There's extra at the jail. So do you want to do that? How old are you?
I'm 22. I recently turned 22 like 2 months ago. 22.
All right. So what are you doing with your life other than smoking marijuana and not reporting to probation?
I'm starting to work. I'm working at a door company and just trying to stay out of trouble and stuff.
All right, so you need to start asking yourself, because some people think, marijuana, no big deal. You need to ask yourself, is smoking marijuana worth you going to the state jail facility
No, it's not.
or going to Bexar County Jail?
No, it's not.
And I know that they didn't go on this, but I see that one of the substances that's alleged to have been used is cocaine. So I need to make a determination on what is best for you. So have you used cocaine?
No, I haven't. No.
Never?
After that one, I haven't. No.
Where do you live? Do you live by yourself?
I live with my mom.
All right, so where are you smoking your marijuana?
I'll go to my friends and I'm just trying to stay away from them also.
All right, so you know we have something going on called COVID. Do you love your mom?
Yes, I do.
All right, so I already know that when people are using drugs, they're not as careful as they should be. So your mom is providing a roof over your head. I'm sure she's feeding you, right? You're not paying electricity, you're not paying the water bill. You understand?
Yes, ma'am.
Right, so you're gonna have to start being an adult and taking care of your business. And part of your business is this probation. Do you understand?
Yes, I understand.
Right, so people come into court all the time. I used to be a defense attorney and prosecutor, right? So they come in, they are nervous as all get out because they think they may be going to prison. And even though the state and defense have come up to this agreement, I can still send you to state jail facility. You understand?
I understand.
So people are nervous. They think they're gonna go to prison. And then when they don't end up going to prison, they get excited and they're like, whew. And everything that they promise they're gonna do, that goes out the window after a week. Don't be that person, you understand?
Yes, ma'am.
Because if you're that person, you could end up going to the state jail facility for 2 years, and that's day for day time. And you can think about your life and, you know, the biggest life's question for 2 years, you understand?
Yes, ma'am.
So how far did you go in school?
What was that?
How far did you go in school?
Then the classes they gave me, or like, oh, I went to high school. I graduated from high school. I got my diploma.
All right, so what are your plans? You're only 22, you have so much of your life ahead of you. What are your plans for the rest of your life?
I actually want to go into collision repair.
I'm sorry, what?
Collision repair?
Air conditioning
No,
repair?
collision repair. Like
Collision repair?
Yes.
What are you doing to make that dream come true?
I haven't been doing nothing lately, but I'm actually like trying to look into classes and stuff like that.
All right, don't spend your years planning to do something. You got to actually start doing it. Do you understand?
Yes, ma'am.
All right, I'm going to deny the motion. Alter and amend conditions to include felony drug court. And you're going to be doing the UA hotline. If you miss that UA hotline, you know what's going to end up happening? I'm going to get one of these back, and it's going to be a motion asking whether or not I want to sign this. And you already know the process if this is signed, right? A warrant is issued, you go to jail. Hopefully your mom, because you're not doing it, can bond you out. You understand? All right, I'm going to do that, and I'm going to want field visits because I see I'm not the person who placed him on probation. So I'm going to want field visits 2 times per month for him until he's accepted into felony drug court. And we're going to do a curfew. And that curfew is going to be at 6 p.m. unless you're at work. So you need to be at your home before the street lights come on. You understand?
Yes, ma'am.
And as long as you're living with your mom, you need to follow your mom's rules. So help her out around the house, sweep the floor, do the dishes. You know, back in my day, you didn't have a dishwasher. You actually had to hand wash the dishes and hand dry them. So you have it
I
easy.
actually still do. I help her wash dishes and stuff, so.
Don't
my
help her,
hand-
just do
yeah,
it,
yes.
okay? And clean up around the house. That's what my grandmother would always say, clean up. You're bored, clean. All right, so that's what we're gonna do for him. And if we could make sure that he's put on the list for felony drug court as soon as possible. Ms. Abrams, is there anything else that he needs?
The only other thing, Your Honor, is to be accepted in the felony drug court program, he would need a year left on his probation. He does not have that right now. So
We'll
the
extend it for 1
extension.
year.
Okay, thank you.
All right, so we're gonna extend you for 1 year. If you prove that you are doing things great, then what will end up happening is felony drug court will send you back here and let me know that you're graduating. I'll show up for your graduation and you'll be early terminated. So all of this is within your power. All right?
Thank you.
All right, you're welcome.
Thank you, Your Honor.
You're welcome. I'll just wait in the back and probation will go over things. All right, the party's here for Damone Wyatt.
I was just talking.
Okay.
It was Judge, or I'm sorry, Charles Monk, and we're talking.
All right, thank you. Billy Taylor Denise, is that person here yet? All right, I see you, Ms. Taylor, just give us a moment.
He was here, but. Yeah.
All right. All right, John Gabriel Guarado.
I'd like to defer to the state. They have no official position on this matter. What I'm looking for is to reform the judgment to make it instead of a no contact, no harmful injurious contact. But you've already sentenced him. He's in TDC right now. The complaining witness wants to go visit him and bring his son to go visit him in TDC, which they won't let him do if he's got a no contact order, which makes sense. So that's what I'm looking to.
How old is this son that she wants to have him visit him at the prison?
I can't tell you because I don't know.
Oh, no. Yeah.
Let me
Well,
rephrase.
let's find out how old that children is.
I'll find out. Any other questions I can ask her? You see her affidavit attached to it saying
Yes.
she wants, okay.
Yes.
So any other questions I can ask her while I can get her on the phone?
Oh, yes, sir. But I will tell you, I have a problem with people taking children to prisons and jails to see people in prison and jail.
Okay.
Because to me, that's a consequence that somebody's giving their child because somebody did something. And jails are journey places.
Okay.
There's nothing worse than people taking infants who don't have their immune systems built up to go visit somebody at the jail. It's not clean. And neither is the prison. So I want to know how old the son is. Yeah.
I'll find that out. And in addition, is there any other, I'm sorry, I rephrased the question. Is there anything else I could get from her to talk to you? Is there anything else you look for? Is there anything else?
No, just that.
It's just that information.
All right, thank
Oh,
you.
the second thing, Judge, sorry, when I'm thinking out loud, is that she also, for parole purposes, he would be allowed to parole to her residence theoretically. And to see his children, it would not be if that was.
All right, thank you. All right, are the parties here in Jasmine, Colorado? All right, welcome back. Okay. I still remember all of the testimony up till a certain point.
Yeah, I would I would imagine that you would. It did make an impression, but thank you.
All right, we're going to go back on the record from weeks ago, Brenna, on 2021 CR 10726, State of Texas versus Jasmine, Colorado. If I can have parties announced for the record.
Ryan Groomer for the state.
Jim Oldersdorf for Jasmine, Colorado.
And are you Jasmine, Colorado?
Yes, sir.
All right, and where we left off with the testimony, I believe her mother was testifying.
We had concluded that. I just talked to the mother who's present and she verified that I think we had concluded her testimony. And as I recall, I was talking to the court with regard to the next witness, which was going to be Jasmine.
No, we had not concluded the mother's testimony. I want to say, if I'm correct.
I don't think we did.
No, I want to say about 10 minutes of that.
Oh,
We
okay.
couldn't understand anything.
May I
Yes.
bring her back up? Ms. Arnold, please.
Ms. Arnold, if you could raise your right hand, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes. All right, I'm going to need you to speak up for me, please. Yes. All right, and defense counsel, how far you had proceeded with her is we got her basic information and you were asking the question about where your client would be living.
Thank you. Well, Ms. Arnold, you and I met in the hall. We thought it was all done with you, but our memory is not as good as the judges. So with regard to Jasmine, in PSI it talks about where Jasmine might live, but can you tell us about that?
She'll live with me. She was living with me before, and she'll still continue to live with me.
Okay. Who's in the home besides yourself?
Just me.
Just nobody on probation or
No.
parole or anything like
No.
that? Was Jasmine working?
Yes, she was working.
What was she doing when she was arrested?
She's working at Boost.
At Boost?
Boost Mobile.
Oh, Boost Mobile, okay. You remember how long she'd been there when she was arrested? Just a rough idea is fine.
3 months.
3 months? Okay.
She's still in school.
What, she was still in,
She's still in school, so.
okay. She was working at Boost. She was still in school also, so that was a job and then she had school as well. What grade was she in?
She was back in 11th.
11? Where at?
They were doing online.
Yeah, speak up just a little.
They were doing online.
Okay. But it was through.
She's from Northeast Independent School District.
Okay, through Northeast Independent School District online. Okay. And working at Boost. What was her job at Boost?
She would customer service.
Okay.
She tell you about the phones.
What was that? Was this before COVID, I guess? or-
No.
No, COVID already started. Was this from home remotely, in other words, or was this at a?
The job was at Boost, and then
Actually, at Boost.
and then the online was on her tablet.
Okay. On the tablet. You remember how much you made, just roughly? That's okay. I'm just-
It was like $12.
Okay, $12 an hour.
And she did a lot of training in different stores. They had a lot of different stores. She's really good.
Okay, so she would go to the different, I guess, branch stores that are around town, but it was online, I guess. right, or not?
No, Boost was on at the store, and the school was online for her education.
Oh, so she would actually go to the stores, put the mask on, they were still
yeah,
open.
on
Okay,
bus,
gotcha. Do you think that in the length of time Jasmine's been in jail, which is pretty long, maybe you can help me out on that. How long has that been since she's been in jail?
8, 9 months.
8, 9 months. Have you seen any changes in her approach to life?
Oh, yes.
In what way?
She's always telling me, you know, what she wants to do, and she's always telling me she loves me, and she's sorry.
So you think being in jail maybe made her a little more serious?
Yes. Definitely. She's been real patient, and she doesn't complain at all about where she's at. Yeah.
Do you work? Okay, are you disabled? What's your status? I see. you.
I have arthritis in my both knees.
Okay. You received disability?
No, I was waiting, I was almost on 3 years and I get denied twice, so.
Okay. Would Jasmine be helping you around the house?
Yeah.
Because it looks like it might be trouble with stoop and bend and things like that, right?
I need the surgery, so I'm just waiting.
Both knees or just one?
Both, but one at a time, yeah.
Well, okay.
Yes, both.
Okay, thank you. The gentleman to your left over there is, he may have some questions for you.
Just briefly, you said Jasmine lived with you before this incident occurred, right? So did Jasmine live with you while all the crimes that she is currently facing happened?
Yes.
That's it, Judge. No further questions. Thank you.
All right, thank you for
Thank
coming.
you, Ms. Hall. Thank you for coming out and coming down here today.
A
Appreciate it very
defense
much.
call, your next witness.
That'd be Jasmine, Judge.
All right. Ms. Colorado, if you can raise your right hand for me. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes, ma'am. All right, show me your hand. Defense.
Jasmine, how do you feel about the idea, not the idea, but I mean, it's a commitment. It's not just an idea, about being on probation. Do you know what it would involve? Tell the judge what you think it means to be on probation as opposed to in TDC.
Always reporting, doing drug tests twice a week. I already have my job, like my manager, she had talked to my manager. He says that he's, right when I come out, he's willing to hire me again. So I already have my job status. I do want to finish my high school. I want to apply for college, also be successful on probation too. I can report, I can do everything that y'all assigned me to this probation. And my mom also wants to do her surgery, so I just want to be there for her and help her.
Should she be having some rehab or something? It sounds like, right? Some type of rehab. That's what you're talking about, assisting with for going through that, right? She'd be essentially laid up, it sounds like, right? Have you had a chance to look at the pre-sentence investigation that I'm pulling out of my pocket? And is there anything in here that the judge needs to be made aware of that's incorrect and needs to be changed? Does everything appear to be correct to you?
Yes.
Okay, including the narrative. You take responsibility for your actions in this mess. Okay. You have no record, it looks like, right? Am I correct on that? No juvenile, no. We have several cases here, but you stayed out of trouble, but then now all at one time, you got a bunch of stuff, right?
She said I've been waiting patiently in my time like I'm supposed to.
How long have you been in jail then? What is, does that give you an impression of, gee, this is the way I want to spend my life, or in and out of here? Or?
Like I feel like, and I really don't want to get like prison time. So I feel like the years I would have to do prison time, I can already get my life together, doing this probation successfully. I can do 100% all the way to this. I know I can.
Looks like a bunch of this is you involved with a bunch of other people, right? When you read the PSI, that's what you read, right? Okay, well, what is, have you continued your relationship in jail with these folks? Do they come and see you or write you? You kind of see where I'm going with this, that looks like a lot of what's going on here. When you read the PSI, you see all this, right? Do you have any feelings about the victim in this case?
Yes, and if he was here, I was gonna ask you that I haven't fully been able to forgive myself until I wanted to ask him for his forgiveness. I wanted to turn around and tell him if he forgives me for this.
Your wife's forgiven? You see how it affected him? You remember that? How did it?
He affected him a lot, and I really apologize for that. I wouldn't want anybody to feel like that. And then I felt good too, because he said, how would it feel to him if I was on probation? And he wanted to leave that to y'all as a thing. He wasn't like no or yes.
So he wasn't asking that you be sent away. Is that what you're saying? That's what you're, okay. The gentleman to your left over here has the right to ask you some questions from the DA's office.
Yes, sir.
Ms. Colorado, you said that you hope that the victim is able to forgive you, correct?
Yes, sir.
Do you remember during the PSI process when someone came and talked to you about the case in which we're talking about where he's the victim? Okay. In that report I have here, it states that that essentially y'all got dropped off at the wrong place and the victim came up to you guys and kept bugging y'all. I pulled the knife out because he was threatening us that he was going to call someone to pull up on us. So I took his phone and we took off. He was with someone else and called the cops on us. I was arrested that same day. So whose fault was it? Was it his fault or was it your fault? Because you say that he kept bugging you.
Well, I did tell you it was like a threat, but it just. It didn't really tell us that. Like, I don't hear you. It didn't really like, he wasn't like I thought he was a threat, but because he did come up to us and ask us for some stuff and I took it the wrong way.
Okay.
That's why I said that at.
But you understand, he says that y'all come up to him and pull out a knife and take his phone. You understand that's what he says is the part of the story, correct?
Yes, sir.
Okay, so what is it? Did he come up to you guys or did you guys come up to him or did you come up to him and pull a knife?
Yeah, I did come up to him.
Okay, so what you said here, whenever you told this document that you were going to give the judge that he came up and kept bugging you, that's not true. It's not true. Or it is true, I'm sorry. What's true? What happened? Can you tell us what happened on the day that the case you're pleading to? Can you tell us how you came into contact with the victim?
But I had thought he was a threat at first, but then when I had approached him, he got like kind of like not defensive anymore. So then that's when that happened.
And then you took out a knife and then took his phone?
But I didn't intend to hurt him at all.
Ma'am, you understand right now you're facing charges from 5 different offense states that are being taken as consideration and part of this plea. You have cases of harboring a runaway child, a criminal trespass, a felony burglary of a habitation, a terroristic threat, an unlawful carry of a weapon, an evading arrest or detention, and then finally this aggravated robbery on September 2nd of 2021, correct?
Yes.
Okay. And you picked up those cases in less than 18 months. I'll pass the witness, John.
Todd, any follow-up questions?
Yes, thank you. With regard to the other offenses, was this the burglary, the harboring, was this one individual?
Yes, they were all my misdemeanor charges are from my ex.
Your ex?
And her mother didn't like me a lot, so she would, with the harboring and runaway, she knew that she was at my house, but still decided to call the cops. They asked her if she wanted to press charges, and she said yes. And they didn't give me like no reports or anything, so I didn't even know that was on my record. But her mom did know that she was at my house.
Well, let's address this. You have a burglary of a habitation force, and I'm asking you these questions because you gave up your right to remain silent when you entered the plea. That's from January 19, 2021. Were you with these same friends?
I know it was at my ex's house. I had busted the window.
Okay.
Yeah, ex house starts the day permit. I've learned my lesson on that.
And now you have from September 2nd, 2021, aggravated robbery, and these were with these other people, correct?
It was my ex and my friend.
And then we have the harboring of a runaway from May 4th, 2020. Criminal trespass, private property, January 19, 2021. Terroristic threat of family household, January 25th, 2021. Unlawfully carrying a weapon, July 16, 2021. And evading arrest detention, September 2nd, 2021. I read the stipulations, and in the stipulations, the complainant was walking to school. You were with your friends. You pulled the knife on the complainant and took the complainant's phone. That's what's the stipulated evidence. You understand?
Yes, ma'am.
So is there anything else from either side?
Nothing for this question.
Just a brief follow-up. The cases that you heard the judge talk about, is this one romantic relationship or more than one romantic, or it sounds
It
like.
was just one my ex.
Okay, so it's an ex, excuse me, it's an ex-girlfriend, burglary, harboring, So that was an underage individual, right? Terroristic threats, same individual romantically. Okay, what was the other one? Unlawfully, but I don't think that would have anything to do with being in a romantic relationship, right? That's just a case. Okay. But I just wanted to make sure that the judge was aware that this is one relationship that all these cases, the burglary and like, right? That's her house, right? You're breaking the window, right? That's all we have.
All right, those are the witnesses.
No, Your Honor, we.
All right, Miss Colorado, how old are you?
20 years old now.
All right, so when things happen to us when we're 20, 19, 15, sometimes we think it's the end of the world. But technically, it's not the end of the world because you still have more of your life ahead of you. The thing about situations is that bad things may happen to us, but you have to learn from those. And sometimes people cause bad things to happen to other people, and the people who are causing that have to learn from it. And part of learning from what we do is dealing with consequences. Too many times, people will do things and there's no consequence for it. You understand? So this is what the court is going to do. Court is going to find you guilty, sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with County Court Cause number 668752. Take in consideration 2022 CR 1566, County Court Cause number 660456, 654181, 665480, 665479, JN number 2004667-1. There's to be restitution of $400 to Tyler, Tyler Eccles, Eccles, $200 restitution in cause number 2022 CR 1566 to Leticia Trevino. There's to be no contact with Tyler Eccles, Leticia Trevino, and Ivana Ivana Trevino. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? I'm sorry. All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. All right, we can go off the record. Ms. Colorado, good luck to you. I hope you learn from this experience and make better decisions. Do you understand? And think of others.
Thank you for hearing.
Thank you. All right, Jamone Wyatt. Okay, so. You can have a seat, sir. All right, let's do that as a deadline of your trial. All right, Mr. Wyatt.
Yes, ma'am.
Your attorney is actually in jury selection in another court. So your plea deadline date and jury trial date will be June 21st, okay?
Yeah, thank you.
All right, just wait till you get a reset form.
Yes, ma'am.
Here you are. Oh, just one second. All right, is the attorney here for Billy Taylor? What is happening with Ms. Taylor? Ms. Taylor, if you can come up. Yes.
Yeah, Ms. Taylor has two cases. One of the cases in particular, I was missing some of the videos. I visited with the prosecutor and they were uploaded just this past March. So we'll work on trying to get that. However, her case that ends in 9638, she was originally placed on bond back on November 8, 2020. There was a court date, December 1st, that she missed and was remanded without. She was then picked up February 24th. And there's a second case that was filed at large for an incident that happened prior to the one on 9638. She has a bond on that one, but we'd like to ask the court to set bond on 9638. And apparently we talked about this issue last time we appeared over Zoom, but for whatever reason, the bond didn't get set. So we're asking that happen this time.
All right, has a motion been filed in?
Not that I'm aware of.
No, no.
Right, I don't have a motion. What I have on my docket sheet is that on December 1st, she was a no-show at 10:58 a.m. So the court issued a bond forfeiture. And then there was a recall for April 12th. The defense attorney was to file a request for bond. And then on February 12th, we didn't have a hearing. Counsel wasn't present. And then we came back, I'm sorry, on April 12th, we didn't have a hearing. Counsel wasn't present. Then we came back on April 13th and you were sent to impact, I believe, for jury trial on this case. So first off, where are we on jury trial?
But once again, Judge, 9638, there was certain videos that I have not had. I visited with the prosecutors on that. Apparently those were uploaded just this past March. So I will work on trying to download that. So because of that, we're not ready for a jury trial.
All right, what about in 221 CR 9636?
That one I would have to announce ready on.
Okay.
But I would ask if we can have time to get the videos on the other one. I believe we could potentially work out a deal on all of it. I just can't in good conscience tell my client such without reviewing that evidence.
All right, Ms. Ferguson, on Miss Taylor, Billy Taylor. When were you born? Were you born in the 80s?
In 82.
You know why I asked that? Are you named after the character in the movie Billie Jean? Brenda, people who are born in the 80s don't know about the 80s movies. I need to remember that. All right, Ms. Ferguson. Ms. Taylor, can you set this for jury trial next week, please? All right, so we're going to come back for jury trial, Ms. Taylor, on May 31st. And defense just filed a motion in the court will hear it. I don't have any motions for bond.
Okay, I have two other cases set, Judge. One is a special setting on the trial on final bid on merits on the civil side, and then I have another case back here. So just so the court's aware, I will have three different settings.
All right, we'll see you on the 31st, and I always have to tell people criminal does take precedent over civil. Yeah.
Well, and again, Judge, it is a special setting. I understand the precedents, but I can only be at one place at a time.
All right, and that'll be 187, May 31st at 9 a.m.
Well, just for the court notification, Judge, I will appear in presiding as that is a special setting, and then I'll come over here right after.
All right, be sure to let Judge Angelini know that.
So are we setting here or are we setting?
Oh, you're gonna be here. And
Also,
Angelini
he'll
will
be
be here.
I will,
Yes.
I'll get with them, Judge, before.
Sure. All right, and your issue?
14-year-old son.
Yeah, I'm not gonna agree to that. All right.
Any particular thing I can say?
Well, I mean, there's nothing I can do other than deny it to stop the people from taking children to prison.
What about she's allowed to visit, but he's not?
There's nothing, I can't put that in your order because once the no contact order is lifted, she's allowed to do whatever she wants to. I don't have any jurisdiction over her child. Who I don't even know if they really want to see their father.
Fair enough. So denied at this time, I can report that back to them. That's the.
Yes.
Thank you. I
All right, thank
appreciate you. And thank you for hearing that today, by the way.
Sure, no problem. All right, who are the parties on Michael Jimenez? Michael Jimenez. Oh, no, just have a seat. I'm waiting for your attorney. All right, if you can come up, Mr. Jimenez. I'm taking them in order, Mr. Martinez.
I don't just, I took it out of order, put it back at the bottom, and I believe it's another county.
All right. Okay, Brenda, these are two cases.
Okay.
All right, the court is calling 2022 CR 4833W and 2022 CR 4832W, State of Texas versus Michael Jimenez. Can I have parties announced for the record, please, for the state,
Brittany Sparks.
for the defense?
Robert Brabant.
And are you Mr. Jimenez?
Yes, ma'am.
All right, defense, in each of these cause numbers, I'm showing you the discovery acknowledgement. Have you received the discovery in all of these cause numbers, in each of these cause numbers, and did you review that with your client?
Yes, ma'am, I did.
Then in each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Jimenez, in each of these cause numbers, I'm showing you what's entitled waiver of indictment and reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Did you understand in each of these cause numbers, you have a right to have a grand jury hear the evidence in the causes and make a decision on whether to indict?
Yes, ma'am.
And do you also understand your attorney has certain rights, namely 3 days from the presentation of the information, 10 days from the presentation of the information to prepare, 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand?
Yes, Your Honor.
And did you understand by entering the plea bargain agreement in each of these cause numbers, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers? Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived reading of it and information, waiver of indictment, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In each of the cause numbers, I'm showing you what's entitled information. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
Yes, ma'am, I do.
State, are you proceeding on the information as presented?
Judge, in one of the cause numbers, I believe we're waiving the repeat enhancement.
All right, and that would be in cause number 2022 CR 4832W.
Yes, Judge.
Any objections?
No objection.
Mr. Jimenez, did you understand in cause number 2022 CR 4832W, you're charged with burglary of a building with intent to commit theft? And in cause number 2022 CR 4833W, you're charged with the offense of total mischief, $2,500, but less than $30,000. Did you understand that those are state jail felonies? The range of punishment is anywhere from 180 days to 2 years in the state jail facility and up to $10,000 fine.
Yes, Your Honor.
If you have a plea bargaining agreement with the state in either of those cases, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering the plea bargaining agreement in each of these cause numbers, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargaining agreement in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to these offenses?
Yes, ma'am, it is.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do.
Mr. Martinez, I'm sorry, Mr. Jimenez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial in each cause number. In each cause number, I'm showing you the plea bargaining agreement. Did you review those documents with your attorney? Did you understand that?
Yes, ma'am.
In each of the cause numbers, your punishment is to be assessed at 2 years in the state jail facility. The cause numbers will run concurrently, and the state will take in consideration the following county court cause numbers: 668, 563, 679, 409. Did you understand that to be the plea bargaining agreement?
Yes, ma'am.
Defense is at the plea bargaining agreement.
Yes, ma'am, it is.
State is at the plea bargaining agreement.
Yes, Judge.
And each of the cause numbers, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then, in cause number 2022 CR 4832W, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2022 CR 4833W, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Judge. State offers States Exhibit 1 and all attachments in both cause
No,
numbers.
no objection, Your Honor.
Mr. Jimenez, in each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Then in each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and each of the cause numbers, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty in each of the cause numbers. Are you proceeding with sentencing?
Yes, ma'am.
Is there anything you wish to say on behalf of your client?
No, Your Honor.
Then in each of the cause numbers, the court will follow your plea bargain agreement. In cause number 2022 CR 4833W, court will sentence you to 2 years in the state jail facility, giving you credit for any time served. This will run concurrent with 2022 CR 4832W. Taking consideration county court cause number 668-563, 679-409. And in cause number 2020 CR 4832W, court will sentence you to 2 years in the state jail facility, give you credit for any time served. This will run concurrent with 2022 CR 4833W. Taking consideration county court cause number 668-563, 679-409. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Mr. Jimenez, in each of the cause numbers, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review those documents with your attorney? Did you understand them and did you sign them?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or an ammunition is, you'll need to speak with an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Jimenez. You can go off the record, Mr. Jimenez. You're gonna have to start making better choices. Are you gonna find yourself spending a majority of your time in custody? You understand?
Yes, ma'am.
All right, good luck.
Thank you.
Mr. Prorax, want to give back to your client?
Thank you, Judge.
You're welcome. Hi.
Just stopping by, make sure everything's okay.
Yes.
Been taken care of.
Yes. Oh, and I need to send you, I need to fill out the form that you sent me.
Want me to send it again?
Yes, and I'll fill it out today.
Excellent. And now type in the specific dates, times and all that. I may have already, but just in case.
Okay, awesome.
Thank you so much. Nothing feels like.
All right, you too. Hi. Thanks for dropping by.
I see that.
Yes.
On Miss Colorado.
Yep.
The parties here on Mina Blue, Wilson, Goetner. Am I pronouncing all of your names correctly? Oh, how do you pronounce it?
It's Gauthier.
Gauthier? All right. No, names are important. If someone mispronounces it, you should always let them know the correct pronunciation. All right, the court is calling 2021 CR 5527, State of Texas versus Mina Blue, Wilson, Gauthier.
Gauthier, yes.
Okay. Can I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
Dennis Callahan.
And are you Miss Wilson
Yes, ma'am.
Gauthier? All right. I'm going to show you what's entitled Application for Deferred Adjudication of Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of controlled substance killing for 1 gram to 4 grams? That's third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, and for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Gauthier, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargaining agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived a right to jury trial. Showing you the plea bargaining page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargaining agreement, there's to be $1,000 fine probated. State recommends deferred adjudication. Will take in consideration county court cause number 629035. Did you understand that to be the plea bargaining agreement?
Yes, Your Honor.
Defense is at the plea bargaining agreement.
Yes, Your Honor.
State is at the plea bargaining agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargaining agreement. The state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 120 hours community service restitution, and you're to follow treatment recommendations from the TAP evaluation and mixed mild evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged and indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Judge. State office states Exhibit 1 and all attachments.
No objection.
Ms. Gautier, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, if you understand, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, but the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
She admits she's got a binge drinking and drug problem. She's anxious to get rid of that problem. I think she would be a good candidate.
All right, do you have any children?
I do not.
All right, how far did you go in school?
I graduated and then I spent like a year at San Antonio College.
So the person who's listed in the report 01, who was that?
He's actually my ex, and that's
Jose Ramirez is your ex?
Yes.
So how often were you using drugs?
Really not too often. It was really just him. Like I said, I'm just going to say no contest because I know it's just gonna take forever if I don't. Just go with it.
No, I mean, if you want a jury trial, we'll give you a jury trial.
No.
So, I mean, here's the thing, when people accept plea agreements, stop pretending like we're up here for no reason. We're here because obviously I've read the report and you have a drug problem. Either you want help for your drug problem or you don't. Either you want help for whatever issues you have or you don't. If you don't, then guess what? There are other people who need the spots that I'm gonna give you.
For sure.
So if you don't have a drug problem, and if you want to come to me with like, I was using maybe just a little once in a while, then fine.
I definitely need assistance with that.
So what drugs have you been using?
Just marijuana and then cocaine.
All right. Does anyone want to check on her to make sure she's okay? All right. Does she need water?
That might be what.
Brenda, that has happened to me on several occasions. It is not fun. All right.
Ryan Grimmer substituting for Brittany Sparks.
All right. So what drugs have you been using?
And just marijuana and then cocaine at the time.
All right. What have you used in the past?
Marijuana and cocaine.
All right. Anything else?
Well, no. I mean, after that, I did, with that same gentleman, I tried to commit suicide and I got a hold of something called GHB or GBH, I don't know. But I did that. And so that might be like, but that was 2 years ago. So I don't think that's.
So where are your parents?
They're separated, but my father's at work, so he couldn't, I guess, be here. But he's pretty much trying to get me back onto and away from that man, so that's why it's kind of.
Are your parents in San Antonio?
They're here, yes.
All right, have you ever been employed?
Yes,
Doing what?
bartend and serve.
All right, this is what the court is gonna do, $1,000 fine, that'll be probated. 2 years deferred adjudication. Taking consideration county court cause number 629035. 120 hours of community service restitution, 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to do that, but if you do 40 of those hours will be waived. I want a referral to felony drug court while in custody. MIC evaluation while in custody. Proof of employment within 30 days of release from custody. There's to be no employment as a home health care provider with minors or any employment that involves you serving alcohol, and you're not allowed to work in any establishment whose primary purpose is to sell alcohol. You understand?
So we're gonna hotel. Like, I don't,
Yeah, I mean, you can work at a hotel.
but I work in like this, we serve like, I mean, they drink.
You're
mimosa.
not allowed to work in a bar.
But so it's not, that's what I mean, it's the hotel, but I mean, we do serve that, but it's not a bar.
All right, here's the thing. If you're at a hotel and you're working behind the bar where they have drinks and you're making drinks for people
Oh,
and
no.
giving it to them.
It's more
No.
of serving at that location. Yes.
She's not to work as a bartender. She's not to touch alcohol. She's not to mix drinks. This is not the movie Cocktail with Tom Cruise. She's not allowed to do any of that. Anything that Tom Cruise did in Cocktail as a bartender, she's not allowed to do. So touching drinks, flipping glasses in air, none of that. You're not allowed. You understand? And once you are fully into your sobriety, the court will reconsider. But I'm doing this to remove temptation from you, okay? Because once people, if they're not fully in their sobriety, they start drinking, then it becomes other things. There's to be no contact with Jose Luis Ramirez. What are you planning on doing with the rest of your life? Are you planning on working in a hotel for the rest of life? What do you want to do?
No, I mean, I was going to school for business and management, to kind of figure out how I was gonna be, because I do hospitality work, or, hospitality, is where I thrive in. But I was at this point trying to go more toward medical, just because medical's a thing and everyone, it's more.
Well, let me just, I don't want to step on anybody's strings. But anytime you have a felony case or any type of case where you're on paper, and you are trying to get employed in any type of thing that requires a license, they may deny it. So this is what the court is going to do. The court is going to also, with regards to your community service hours, if you get a degree, a higher degree in business management, or if you get a certificate from a trade school, a real trade school, then the court will waive the remaining of your community service hours. So you can do the community service hours, or you cannot do them and benefit yourself. Do you understand? There's to be regular reporting by Zoom or in person. If you're not allowed to report in person, or you can't report in person, you'll need to report by Zoom. If she's not accepting the felony drug court, then I'll try her with intensive outpatient treatment first. The UA hotline, field visits, 2 times per month, random. Is there anything else that she needs, Ms. Abrams?
No, Your Honor, I believe you covered it.
All right, is there anything else you need from the court in order to be successful in this deferred adjudication? All right, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you. Probation will go over conditions with you. Robert Andrade.
Usually this is.
Yes, are you
Sorry about
okay?
that.
Oh,
Yes.
no problem. It's happened to me several times. Denny. Andrade.
I need to file this. Right?
All right, did you confer with Mr. Villarreal?
I did just.
All right, so Mr. Villarreal, we're not on the record on this case. I had made an order and that order wasn't to take effect till May 30th, so that complainant could be aware. And it was for him to have employment. But the court was under the understanding that the complainant was not in Bear County, that she was in Universal. Now I'm being told that she's not in Bear County.
But she is in Bear County.
I'm sorry, that she is in Bear County, yes, and
Yeah.
not in Universal.
Yes, Judge.
So we need to figure out, if I'm allowing him to work, we need to figure out what the zone is where he just can't be in that zone at all.
Are we able to do a certain distance from the address?
Yes, we could.
Obviously, I don't want to put her address on the record. Judge.
Yes, no, we will not. What I'll do is I'll hand you both the order. And what I'm going to do is I'm going to show you what the court previous order is. So the only thing that will be changing is the zone. And I want to make sure that Mr. Andrade has a copy of it.
Okay.
So,
And Judge, the address that he referenced yesterday is actually the address that's still the address. So he knows about it. GPS knows about it.
Okay.
But we will say.
so if you all can put the location in that order for me.
Okay.
And then I'll do the rest.
Okay. You want me to just put it at the bottom, Judge?
Yes. And then, Mr. Martinez, once I finish writing that in, want to make sure that your client has a copy. And we'll put on the record that he's been given a copy and he knows where he's not to be. All right, the people who are going to be called up next is going to be Antoinette Garnica, Roberto Espinoza. Oh, just one moment. And then it's going to be George Moore. And then it's going to be Joel Milton. So that's the order in which you guys will appear. And then after that, the court is going to take its lunch break. Thank you.
Your Honor, what was the first name for Mr. Milton?
It's going to be Garnica.
Gardner Milton?
Garnica.
Not Zachariah.
Yeah. And Mr. Villarreal, how much distance do you want from him from this location?
We could do 1,000 feet, Judge.
Yeah, you're there.
The fourth one, okay.
All right, can I have Mr. Robert Andrade, please? Court is calling 2020 CR 1052, State of Texas versus Robert Andrade. Can I have parties announced for the record, please, for the state,
Michael Billiard, state.
for the defense?
Raymond Martinez.
And are you Mr. Andrade? All right, Mr. Andrade, the court has changed the court's order. And this order is going to be entered on May 30th, so that's when he can begin his work. The court is placing, I'm sorry, the court is allowing the defendant to work from Monday to Friday from 9 a.m. to 5 p.m. You're to provide a 48-hour notice of your work schedule. And if you need supplies for your work, you're to provide a 48-hour notice to pretrial services that you need those supplies and the location of those supplies. Do you understand?
Yes, ma'am.
The GPS fees will be waived, or you will be placed on indigent status. So if they can't waive it, then it will be indigent status. And you are to not be within 1,000 feet of the address that your attorney has made you aware of. Do you understand?
Yes, ma'am.
And you are aware of that address. Do you understand?
Yes, ma'am.
And you understand it goes without saying that you are not allowed to contact the complainant in any way. Do you understand?
Yes.
And this is the only thing that the court is allowing you to do. So the court is not allowing you to make any other unauthorized stops. You understand?
Yes, ma'am.
All right, is there anything else from either side?
Judge, I'm going to be filing a motion to remove a no contact order with a complainant from another case that's already closed that somehow got included in the no contact order with this complainant.
Mhm.
I just wanted to mention it for Mr. Andrade's benefit that I.
All right,
will be
and Mr.
presenting that to the
Martinez,
court.
that is the order. So, Mr. Andrade, I want you to read that order. Yeah.
This is what we're interested in.
Excuse me, no, we're not putting the address on the record, okay? My question to you is, have you read the order?
Yes, ma'am.
Do you understand it?
Yeah.
And do you understand the location where you're not supposed to be within 1,000 feet?
Yes, I know.
So you can pull out the GPS, you can pull out Google, but you should know that you're not to be within 1,000 feet of that address. Do you understand?
Yes, ma'am.
All right, thank you. And that will begin on May 30th. If you'll file it, have it file stamped with the clerk, and then your client can have a copy of it. All right, who are the parties on Antoinette Garnica? All right, the court is calling 2020 CR 0679, State of Texas versus Antoinette Garnica. Can I have parties announced for the record for the state,
Michael Villarreal, state.
for the defense?
Jackson Lindsay on behalf of Ms. Monica, judge, ready to proceed.
And are you Ms. Garnica?
Yes, I am.
All right, Ms. Garnica, I'm showing you what's entitled application for deferred adjudication. I'm sorry, application, I'm sorry, motion to enter application. Oh, where is my mind, Brenda? It's, see, I'm looking at the clock and I'm trying to speed it up for you, but I need to slow it down.
Yes.
All right. I'm going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Are you the same Antoinette Brianna Garnica, who was placed on deferred adjudication in 2020 CR 0679 for the offense of aggravated assault with a deadly weapon on July 23rd, 2021 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 1, on or about the 4th day of March 2022 in Bexar County, Texas, for defendant Antoinette Brianna Garnica committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
The state would waive and abandon the remaining allegation.
Any objections?
No.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. The agreement to deny the state's motion and alter and amend conditions of probation to include state ISF, both the cognitive and substance abuse tract. And once she's finished with that, she have ISP supervision. And as part of the agreement, the state is going to take into consideration cause number 2022 CR 3424, which is the new number 1 that the defendant spoke to.
All right, defense, are you asking the court to follow that agreement?
Judge, I thought we were doing a 60-day jail sanction with ISP supervision. If you recall, the last time we were in court, my client went, we were in the middle of the plea process and the court asked her, do you want me to take the true, knowing that you can sentence her up to the max? And I think at that point in time, she decided to change her plea because she was
She wanted to
under
contest
a lot of anxiety. I don't think it's a matter of contesting it, Judge. I think it's just a matter of making sure we're all on the same page, if you excuse me.
All right, so I'm trying to figure out, Ms. Garnica, why I shouldn't just send you to prison. You're on probation or deferred adjudication for aggravated assault with a deadly weapon, and now you picked up an assault. So the state is requesting that you go to both track state ISF. And then you're continued. So do you wish to do that, or do you wish to go to prison? I mean, it's up to you. If you want to go to prison, I'll send you to prison. I'll send you to prison for 3 years.
May I ask, would I even be accepted in ISF being pregnant?
Miss Abrams, will ISF accept her if she's pregnant?
Not if she's gonna have the baby while she's home, so we have to find out.
Just how many months, if I may ask?
I'm 7 months pregnant.
7 months.
She would have the baby first and then she would go.
1 second, Judge.
All right, thank you. Are you okay with
Your
that?
Honor,
Finish the please. Yes.
she would have to have the baby first before going into state ISF.
All right. Well, this is the thing. The court has your plea of truth. The court is accepting your plea of truth. And you'll need to confer with the state again, Mr. You need to confer with the state.
Understood, Judge.
All right, because she's not going to be accepted into ISF. So I've had your plea of truth. We're going to come back after the lunch break. Unless you all come up with an agreement before then.
I mean, I might have a misunderstanding, Judge. This is something that Michelle handled previously. And she agreed that it would be continued. And Mr. Lindsay's notes reflect that it was actually an agreement of 60 days. The jail sanction, a new TAP evaluation, and ISP supervision.
That was our understanding, Judge.
Okay, what is case being taken into consideration?
It's an assault family second case.
What's the cause?
Cause number 2022 CR 3424.
All right, this is what the court's going to do. Court is accepting your plea of truth. The court will deny the motion. Alter and amend conditions. What is going on here? Is there a drug issue? What's going on?
There's no
Or
drug
just a
issue.
violent issue?
There's no drug issue. It's more of a trauma issue. And I'm currently in reentry through the jail programs.
Okay.
Completed half of that program.
All right, what we're gonna do then is I'm gonna alter the main conditions to include a MIC evaluation. That'll be done while you're in custody. If you could have them expedite that. Who is the complainant in the other case? And does the complainant wish to be with Ms. Garnica?
He is not cooperative.
All right, what is his name? What is his name, Ms. Garnica?
Eli Vincent Lopez.
All right, there should be no contact with Eli Lopez. Taking consideration 2022 CR 3424. State, was there any drug issues with this case or not?
No, it appears that there's an argument over, I believe, potentially alleged infidelity.
And we're going to do parenting classes, field visits upon release. And that'll be 2 times per month. And there should be regular reporting by Zoom or in person. Random UAs. All right, good luck to you.
Thank you, Your Honor.
You're welcome. Probation will go over conditions with you. Ro- Roberto Espinoza.
He's present, Judge.
Brendan, this is 2 cases.
Yes.
All right, the court is calling 2020 CR 4377 and 2020 CR 4378, State of Texas versus Roberto Espinoza. Can I have parties announced for the record, please, for the state,
Michael Villarreal for the state.
for the defense?
Alex Sharp for the defense.
Counsel, each of these cause numbers, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in each of these cause numbers, and did you review it with your client?
Yes, I received them, and yes, I reviewed them with my client.
And each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Espinoza, and each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Counseling, each of the cause numbers, do you waive the reading of the indictment?
We do, Judge.
Mr. Espinoza, in each of the cause numbers, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
State in cause number 2020 CR 4377, are you proceeding on the indictment as presented?
There you are. State proceeding on the lesser included offense of indecency with a child by contact.
No objection.
And in cause number 2020 CR 4378, state, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Espinoza, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
Did you understand in each of the cause numbers, you're charged with indecency with a child by contact? That's a 2nd-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication in each of these cause numbers, if for any reason your deferred adjudication were revoked, the court could sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to these offenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I
Do
do
you believe
believe that.
he's currently competent, was legally sane at the time of the offense?
Yes and yes.
Mr. Espinoza, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter these pleas?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand them?
Yes, Your Honor.
In cause number 2020 CR 4377, state is proceeding on a lesser included offense of indecency with a child contact. In each of the cause numbers, the state is requesting that your punishment be assessed at a cap of 12 years in the prison. There's a $1,500 fine. State opposes your application for deferred adjudication. Each cause numbers will run concurrent. There's to be chapter 62 compliance. There's to be no contact with the complainants or their families. Did you understand that to be the plea bargain agreements in each of the cause numbers?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, it is.
State, is that the plea bargain agreement?
Yes, Your Honor.
In each of the cause numbers, I'm showing you what's entitled waiver of repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then in cause number 2020 CR 4377, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And in cause number 2020 CR 4378, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence to support the plea?
Yes, Your Honor. In each case, state offers state exhibit number 1 and its attachments.
No objection.
Mr. Espinoza, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, Your Honor.
Did you understand that today in each of these cause numbers, the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence its exhibits 1 and attachments in each cause number and consider the same. Off the record, Ms. Ferguson, I'm going to need a date for sentencing. And it's a PSI report. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you apply for deferred adjudication. All right, this will be set for sentencing. I'm going to see if we can get a sooner date. Can you ask Ms. Ferguson, is August 8th the soonest that we can do a sentencing on this? So far, the date that I've been given is August 8th. And is there a need for a TAP evaluation?
I don't believe so, but up to the court.
Okay. All right, we can do a TAP evaluation. They're telling me your sentencing date is going to be August 8th. I'm going to ask that you remain in the courtroom, Mr. Sharp. When Ms. Ferguson comes back, we'll see if we can get a date sooner than August 8th.
All right. Thank you,
All right,
Judge.
thank you.
Thank you.
They need to remain in the courtroom to get a reset on. All right, we're proceeding on George Moore.
President ready, Your Honor, Mr. Moore on bond.
All right, the court is calling 2022 CR 1175, State of Texas versus George Moore. We have parties announced for the record for the state.
Michael Viller after the state.
For the
Marshall May
defense.
on behalf of Mr. Moore, present on bond, ready for sentencing. I mean, for plea.
And are you Mr. Moore?
Yes, ma'am.
Mr. Moore, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, and we have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Moore, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, state's proceeding on count 1 and waiving any count 2.
Any objection?
No objection, Your Honor. It's our understanding of the agreement.
Mr. Moore, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, ma'am.
Did you understand that the court will grant your application for deferred adjudication, and for any reason your deferred adjudication will revoke? Court will find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your Honor.
Mr. Moore, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 1. Punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain
It
agreement?
is, Your Honor. There are no children or marriage in this case.
All right, state, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with
Yes,
your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
None at this time, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 120 hours of community service, restitution hours, no harmful or injurious contact with both Collins and Ellen Collins, and the hostility and aggression control course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense is charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state upper state exhibit number 1 and its attachments.
You've reviewed the document, Your Honor.
Any objections?
No objections, Your Honor.
Mr. Moore, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, the right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Have the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, on behalf of my client, with the state's permission, 5 years was the agreed, Your Honor, but I'd like the court to know my client was on full house arrest for over a year at the residence, Your Honor. I asked the court to consider reducing.
At what residence? The complainant's residence?
Yes.
Okay.
And ask the court to consider, Your Honor. And his parents are here, reducing the 5 years to 4 years, Your Honor, with the credit for that time.
All right. And Mr. Villarreal, with regards to the no harm or injurious contact with both Collins and Ellen Collins.
They're both one. We've spoken to them particularly about this issue. They want to continue to have contact with him. So that's the reason for the state's recommendation.
All right. So is he actually living in the home with Bo and Ellen?
I'd have to double check the court file about that in particularly, but I have no reason to believe that what Mr. Bartolome is saying is correct.
Only with his mom, Your Honor.
Okay. All right. So Mr. Moore?
Yes, ma'am.
What were your issues on this day? I don't understand anyone chasing after their mom with a knife.
Ma'am, I used to have a really bad opiate and benzo addiction for about 5 years. And after that time, I quit, and I've been on Suboxone treatment ever since, and I've been doing a lot better. And I just wasn't in the right state of mind. I was blacked out. I regret it. It's embarrassing.
All right, what do you do for a living?
Nothing right now, but I'm working on getting into work with my dad. I know how to cut glasses and put prescriptions in frames and stuff like that.
His father's an optician, Your Honor.
So how old are you?
I'm 22. I'll be 23 in June.
So what degree or what do you have in order to put prescription in glasses?
No degree. I was self-taught, or not self-taught, but I was taught by like other work opticians, and my father taught me how to in the lab.
All right, should I trust him with my prescription glasses?
Well, Your Honor, I think over time, but he is monitored, Judge. My father was an optometrist, so I have faith in lay people knowing how to do that, Judge.
Did you ever do it?
I learned how to do it when I was 10, Judge.
Should I trust you with that?
You should, Judge. If you ground right, but that's in the days when we ground them on the mill and you put the mud on it and continue to shape the lens. Today they're popped in with prescriptions almost.
All right, see, Ed, you're throwing out a little stuff to make me feel like you actually did it.
I did, Judge.
Okay. It's like, how do you make cake? Oh, you just do flour and eggs, you know, put the icing on there.
My chef, Judge.
Yeah, chef, yeah. All right, so this is what the court is going to do. The court is going to do a $1,500 fine, probated. There's an affirmative finding of family violence. And I'll note for the record that the parents are in the courtroom and they want to have contact with you. There's to be 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, you provide proof, 40 of those hours will be waived. There's to be no harmful or injurious contact with Beau, B-E-A-U, Collins, C-O-L-L-I-N-S, and Ellen, E-L-L-E-N, Collins. The hostility and aggression control force. All right, who are you seeing for your issues with drugs? Because it takes more than just taking a drug to get off drugs.
Right. I cannot think of my doctor's name off the top of my head, but I go to a health net clinic over off of I think 410.
Okay, and other than giving you the medication, what are they doing?
They're providing counseling and stuff like that.
All right, he's to do continued counseling and provide proof of counseling and provide a release. So you're gonna have to do a medical release with probation.
Yes, ma'am.
So they can see what's happening.
Okay.
There's to be regular reporting by Zoom or in person. If you can't report in person, then, I'm sorry, if you can't report by Zoom, then you need to report in person. So probation may still be doing Zoom, they may decide to do in person. I'm gonna want field visits 2 times per month, random. There's going to be 5 years deferred adjudication. You can always ask to be taken off early if you abide by the rules.
Yes, Judge.
So whether or not you're off early or consider releasing you early depends on your actions. You understand?
Yes, ma'am. Yes.
Proof of employment within 40 days. There should be no employment as a home health care provider with minors. Let me see if there's anything else that you need. Just a moment.
Your Honor, will there be a period of time for home visits where we can reapproach the court for that?
Yes.
How
There's
long?
no, I usually will receive reports from probation, and probation will tell me, we've been visiting them for 3 months. Could we consider something else? There's an affirmative finding of family violence. Ms. Abrams, is there anything else that he needs?
Your Honor, did you mention a TAP eval? Did you want a TAP eval?
He's already under care of a physician and receiving counseling, so we're just going to continue with that. But if his ways, if they end up being positive, then the court will reconsider.
Okay, I think that's all.
All right, is there anything else you need from the court in order to be successful? All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am. I do.
Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question about what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, ma'am. I do.
All right, we can go off the record. Probation will meet with you and go over your conditions, and maybe you should just stick to butter knives.
Yes, ma'am.
Which for some reason, that's all they give you at restaurants now. They don't trust you with a steak knife.
Thank you, Judge.
It would be excused, Judge?
Well, he needs to remain,
Yes.
but you can be excused.
Thank you, Judge.
All right, this is the last case I'm taking before we take our lunch break. I'm calling 2022 CR 0693 Zachariah Melton. Could I have parties approach and announce for the docket for the state,
Michael Villarreal for the state.
for the defense?
Forrest Good on behalf of Mary Peterson, the defense.
All right. And are you Mr. Melton?
Yes, ma'am.
Do you have any objections to this attorney standing in for Miss Peters Act?
No, ma'am.
All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, this is not an application. All right, I'm showing you what's entitled True Bill of Indictment, Mr. Melton. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
State, do you waive the reading? I'm sorry, defense, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state's waiving the repeat offender allegation and proceeding on the lesser included offense of assault, bodily injury, married or cohabiting.
Any objections?
No, Your Honor.
Mr. Melton, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married or cohabitation as a class A misdemeanor? The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? Okay, I need you to speak up. Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent and was legally insane at the time of the offense?
Yes, sir.
Mr. Melton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a US citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea agreement page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, married or cohabitation. Punishment is to be assessed at 4 days in the Bexar County Jail. There is no fine and no applications. There's an affirmative finding of family violence, and I'm being informed that the judgment will be satisfied. Did you understand that to be the plea? Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Paragraph, did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that are filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
No, Your Honor.
Mr. Melton, did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Knowing that, do you still wish to continue with this plea?
Yes, ma'am.
Then to the offense of assault, bodily injury, married cohabitation as class A misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. At this time, state after state exhibit number 1 and its attachments.
Any objections?
No, Your Honor.
Mr. Melton, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically, I'm sorry, did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Can't hear you.
Why, is there a reason you're mumbling? Are you able to speak up?
Yes, ma'am, I am.
All right, so you're gonna have to speak up so that she can hear you. Do you understand?
Yes, ma'am.
So, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am, I understand.
And did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, sir.
All right, Mr. Melton, who is the complainant in this case to you?
It's my child's mother, Alicia Esparza, my 3 kids' mothers.
So Alicia Esparza is,
The 3 of my kids' mother.
okay, so she's the mother. And who is Jalen Melton?
That is my daughter.
All right, and are you still living with Alicia Esparza?
No, ma'am, I'm not.
Do you have any contact with her?
No, ma'am.
Right, because I'm gonna order no contact. State, is Miss Esparza aware of this agreement?
She's not, Your Honor. We've reached out all the time and have been able to contact her.
All right, the court will sentence you to 4 days in the Bexar County Jail. You credit for any time served. There's an affirmative finding of family violence. The court will show that the judgment is satisfied, and there should be no contact with Alicia, Alicia Esparza, Esparza. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I understand.
Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am, I understand.
Okay. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Okay?
Understood.
All right, we're off the record. Mr. Melton, mother of your child, you need to treat them with respect, because at the end of the day, that's the mother of your child, whether you like her or don't like her, whether whatever's going on. And if you can't keep your hands off of people, then you shouldn't be in relationships, okay?
Yes, ma'am.
All right, so what is that tattooed above your eye? Yes.
Southbound.
Are you southbound?
It's a mistake of my life that I made when I was younger.
Okay, and then what's with the thing on the side?
Mistake, accept a mistake, and now.
And what is the red thing on the side? Is that a lipstick print?
Yes, ma'am.
Is that supposed to represent somebody's lips, or is just general?
Oh, man, that was my girl or my kid's mother's lips.
All right, was it painful?
Yes, ma'am.
All right, well, good luck to you.
Thank you.
All right, you're welcome. They may need to take your fingerprints. Do you all need fingerprints? All right, then you are excused. And you're welcome. Brennan, you may proceed to lunch. Everyone, we will be back at 1:45.